Here we are going to discuss cheque as a negotiable instrument. Cheque as a negotiable instrument in the form of a bill of exchange drawn always on a banker. The banker has an obligation to honor the cheque unless there are valid reasons to dishonor. A banker issues blank cheques to its customers who have deposit accounts with them. Whenever the customer wishes to make use of the money lying in his bank account, he issues an order to the bank through the cheque to release the stated amount of money in favor of the specified person. This cheque becomes an order to the bank in the form of a bill of exchange. The drawer of such bill is the account holder, the drawee is the bank, and the payee is the person made entitled to obtain the payment. In this module, we will be able to understand the nature of cheque as a negotiable instrument, the basic work done by a banker, the meaning and various types of crossing a cheque, and finally section 138, which lays down the important rule on bouncing of a cheque becoming a punishable offence. Now we are starting with the definition of the banker. The cheques are always drawn on banks, so it is necessary to understand the definition of a bank. A banker is an institution or an individual engaged in banking business. The term banking has been defined as accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by cheque, draft, order or otherwise as per section 5 of the Banking Regulation Act 1949. This act has described a banking company as a company which is doing the business of banking in India. The primary activity of a banking company would be the accepting deposits for the purpose of lending or investing the same. If the purpose of accepting of deposit is not to further lend or invest them, for example, where a company accepts public deposits merely for the purpose of financing its own business, the business would not be called a banking business. Another notable feature of banking business is that the money deposited should be repayable to the depositor on demand or according to the agreement. The demand should be made through an order, a cheque or draft or otherwise, and not merely by verbal orders. A person who maintains an account in a bank is considered to be a customer of the bank. But to be a customer of the bank in real sense, there must be interactions between the bank and the customer involving business of banking, for example, depositing and withdrawing money or taking loans. Merely making use of the services provided by the banker, such as encashing of a cheque, transferring money through a bank draft, for maintaining a locker in the bank, would not create the relationship of banker and the customer. Now we are moving further to understand about the crossing of cheque. Ordinarily, the bank makes cash payment on the cheque drawn upon it at its public counter itself. This mode of payment is a very common method to recover money on a cheque. However, it entails some risk also. A wrong person may somehow take possession of the cheque and obtain the payment at the bank counter. A solution to this problem is the crossing of the cheque. Crossing of the cheque involves different types, namely open or uncrossed cheque and cross cheque. The open cheque is payable as mentioned above at the counter of the drawee bank on the presentation of the cheque. Payment of a cross cheque is recoverable only when it is demanded through another bank and not directly at the counter of the bank. The payee or holder of the cross cheque deposits the cheque with his own bank, and this bank collects the amount on the cheque from the drawee bank and deposits the amount in the account maintained by the holder. Thus, the chances of a cheque falling into wrong hands are removed, as the person who ultimately recovers the payment on the cheque becomes traceable easily. This way, crossing affords security and protection to the holder of a cheque. The next topic involved in the crossing of cheque is the meaning and effects of crossing. A cheque is said to be crossed when two parallel transverse lines with or without any words inside are drawn on the face of the cheque, generally on the left hand top corner of the cheque. Crossing of cheque changes its mode of payment only. It becomes payable into the account of the holder and not at the counter. It does not, however, adversely affect its negotiability. A crossed check remains negotiable in the same way as an uncrossed or open one. That is, it can be negotiated by mere delivery if it is payable to bearer, and by endorsement and delivery if it is possible to order. If the holder of a crossed check keeps no account in any bank, he would have to open an account with the same banker and deposits the check in their account, so that the banker collects his payment on behalf of the customer and credit the same into his account. Another way would be that he may endorse the check in favor of a known person who keeps an account in any bank and allows him to collect the amount in his own account in the bank and then recovers cash from him. Now we are going to discuss the types of crossing. We have different types of crossing. The first is general crossing, where a check bears across its face, generally on the left hand side top corner, two parallel transverse lines without any words or with such words as and company or and company not negotiable written in between the parallel lines. It is called general crossing as per section 123 of Banking Regulation Act. General crossing reflects the simple meaning of crossing as explained above. The holder may deposit his check with any bank of his choice and collects his money through that bank. The words and company will mean nothing at all, but the words not negotiable will reduce the negotiability, as shall be explained later. The second type of crossing is special crossing, where a check bears across its face the name of a banker, that additional name of a bank itself without any parallel lines shall be deemed to be a crossing, and check shall be deemed to be crossed to that banker as per section 124 of the Banking Regulation Act, or the name of the banker may be put within the parallel lines. Such crossing would be the special crossing. The special thing in this, it is the mention of the name of special bank, which alone could be the collecting banker for the check. Where a check is crossed specially, the banker on whom it is drawn shall not pay it otherwise than to the banker to whom it is crossed or his agent for collection, as per section 126. Thus, in the case of special crossing, the payee banker has to pay on the check only when it is presented through the banker specially mentioned in the crossing. Of course, the collecting banker can always act through an agent bank. Sometimes a check may be specially crossed to more than one bank. As per section 127 of Banking Regulation Act does not allow this. It requires that if a second bank has to be mentioned, it must be as the agent of the first bank. According to section 127, where a check is crossed specially to more than one banker, except when that bank to whom it has been specially crossed makes another special crossing in the name of another bank for the purpose of collection, the banker on whom it is drawn shall refuse payment thereof. A special crossing introduces greater safety than a general crossing, because it would become more difficult for a wrong person to collect payment on such check. The third type of crossing is not negotiable crossing. As we have discussed earlier also, the words not negotiable may also be written in both types of crossing, general as well as special crossing, as per section 123 and 124. A crossing on a check with these words is termed as not negotiable crossing, and it will restrict the negotiability to some extent. Section 130 states the effect of such a crossing in the following words. A person taking a check crossed generally or specially, bearing in either case the words not negotiable, shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. Thus, the effect of such a crossing is that it deprives the check of the essential characteristic of a negotiable instrument. So, no one can become the holder in due course of such a check. Although the instrument remains transferable, it is essentially negotiability stands diluted by this type of crossing. The object of not negotiable crossing is clearly to afford extra protection to the holder or drawer of a check. Even if such a check goes into wrong hands, from there it is transferred to some other person, and from some other person it is transferred to a holder in due course, the true owner will not lose his rights against such an endorsement. Thus, such a cross check must be accepted with extra caution about the antecedents of the endorser. The next type of crossing is account payee or restrictive crossing. Another way to give additional protection to the payee of a check is the practice of restrictive crossing. This is commonly known as account payee only crossing. Such crossing can be made in the case of both the general as well as special crossing by putting in between the parallel lines some restrictive words. For example, account payee only, or Ramnath account only. The implication of account payee crossing is that it is an order to the collecting banker to credit the amount of the check to the account of the payee or of the particular name only and nobody else. This does not mean that an account payee cross check is deprived of its negotiability, although the ultimate receiver of money on this check would be the payee, but still such a check remains transferable, at least technically. The check may be put at circulation and the people may be ready to accept the check because of the goodwill of the parties. The final holder may seek the help of the payee in recovering his money by handing the check over to him, or may recover his money from the transferor or earlier parties to the check. The liability of the collecting banker is increased in the case of a check carrying account payee only crossing. In case the proceeds get credited to any person other than the payee and the last endorsement in favor of the payee is proved forged, the banker will be held guilty of negligence and will not be entitled to the protection given under section 131, where a banker acting bona fide will not be liable to the true owner if the receives payment of a cross check for a customer whose title is defective. Thus, the collecting banker must act very carefully and make proper inquiries as to whether the last endorsement is genuine or not. Now, the question arises, who may cross a check? Crossing of an uncrossed check by a holder is not seen by law as material alteration, which affects the validity of the instrument. Obviously, the drawer of a check may cross it generally or specially at the time of issue or may not cross it at all. Section 125 permits the crossing being made even after issue of a check in the following ways. First, where a check is uncrossed, the holder may cross it generally or specially. Secondly, where his check is crossed generally, the holder may cross it specially. Thirdly, where a check is crossed generally or specially, the holder may add the word not negotiable. Fourthly, where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker as his agent for collection. Crossing on the check once made becomes a material part of the check, and any change in that will amount to material alteration, which may invalidate the check. Only the drawer of the check himself is entitled to cancel the crossing by writing suitable words to that effect along with this full signature. Thus, where a check is crossed account payee only and the holder alters it into a general crossing by striking out the words account payee, and the alteration is irregular and would discharge the instrument. Now we are going to discuss the meaning of bouncing of checks. A check is said to be bounced or dishonored by non-payment when the drawer banker of the check refuses payment upon being duly required to pay the same. Unless there are valid reasons to dishonor a check, the banker must take utmost care to see that the checks drawn by their customers are duly paid when presented. This is necessary to maintain the high acceptability of the check in the commercial world as negotiable instruments. Now we are moving on to a very powerful and strong section, section 138, that gives punishment to drawer for bouncing of checks. With a view to make the banking system more disciplined and responsive to the needs of the people in the matters of circulation and payment of checks, changes were made in 1988 in the Negotiable Instrument Act 1881. A major amendment was the insertion of a new chapter, that is chapter 17 in the Act, whose heading is penalties in case of dishonor of certain checks for insufficiency of funds in the accounts. This chapter contained 5 sections, section 138 to 142. Since then, more changes have been made in the provisions of this chapter, including an addition of 5 new sections from 143 to 147. The important features of this chapter as exists now in the Act are discussed as follows. The drawer of the cheque which the bank dishonored rightfully on the ground of insufficiency of funds has been declared as guilty of an offence for issuing such a cheque and liable to face punishment under certain circumstances. This is to ensure that people do not issue cheques carelessly or with a view to cheat others. If the payment is refused by the bank on any other ground, for example, where it is countermanded by the drawer, or it will not amount to an offence by the drawer under section 138. According to section 138, under certain circumstances, a drawer of a dishonored cheque shall be deemed to have committed an offence and shall, without prejudice to any other provision of the Negotiable Instrument Act, be punishable as follows. First, he can be imprisoned for a term which may extend to 2 years. A fine can be imposed which may extend to twice the amount of the cheque, or both of these punishments can be imposed. The requirement for this valid cheque is the penal provisions would be invoked against the drawer of a cheque which has bound if only the following requirements are satisfied. First, the cheque must have been drawn for payment of money to a person for the full or partial discharge of any legally enforceable debt or liability. It shall be presumed, unless the contrary is proved, that the holder of such cheque received the cheque in the discharge of a liability. Secondly, the cheque must have been presented to the drawing bank within 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. The third, the cheque must have been returned unpaid by the drawing bank either because of insufficiency of funds in the drawer's account or which it is drawn, or because the cheque exceeds the amount arranged to be paid from that account by an agreement, for example, overdraft or cash credit arrangement made with the bank. The procedure for this section 138. First, within 30 days of the receipt of the information from the bank about dishonor of the cheque, the payee or the holder in due course, as the case may be, should have made a written demand on the drawer for the payment of the amount of money represented by the cheque. Secondly, the drawer must have failed to make the payment within 15 days of the receipt of demand notice from the payee or holder in due course. Thirdly, a written complaint should have been made to Metropolitan Magistrate or a first-class judicial magistrate by the payee or holder in due course of the cheque within 1 month of the date on which the course of action arose under section 138. That is, on the expiry of the time given to the drawer to make payment to the payee after this notice. However, the court would be empowered to entertain the complaint even after the expiry of the said period of 30 days or genuine difficulties of the complainant. Fourth, there shall be a system of summary trial of such offences under section 143 to speed up the disposal of cases. Fifth, the offences under this chapter shall be compoundable, that is, comprisable. Sixth, if the person committing an offence under the aforesaid manner discussed above, or the provisions, that is, a company, every person who was in charge of and was responsible to the company for the conduct of the business of the company as well as the company itself shall be deemed to be the guilty of offence and shall be liable to be proceeded against and punished accordingly. But a person will not be liable in cases where he proves that the offence was committed without his knowledge or that he had exercised due care to prevent the commission of such offence. It would be clear from the above discussion that the purpose of all these provisions is to ensure a careful and sincere use of the facility of payment by cheque so as not to cause inconvenience or loss to the recipient of the cheques. It goes without saying that the creditor of the drawer does not lose his right under the civil law to claim the amount due to him in case the checks received by him is dishonored. Now we are going to discuss the summary of what we have discussed so far. The very first thing we have discussed in the chapter is the meaning of the cheque. A cheque is a negotiable instrument in the form of a bill of exchange drawn always on a banker. Then we have discussed the meaning of banking. The banking word has been defined under the section 5B of the Banking Regulation Act 1949. The term banking has been defined as accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by cheque, draft, an order or otherwise. Then we have discussed the types of cheques. Cheques can be of open or uncrossed cheque, cross cheque. A cheque can be called uncrossed cheque when it is given without making or without drawing two parallel lines on the transversal lines on the left side top corner of the cheque. Cheque can be called cross cheque when two parallel transversal lines are drawn on the left hand side top side of the cheque. Then a cheque can be crossed in the following ways. It is general crossing, special crossing, not negotiable crossing, account payee or restrictive crossing. A cheque is said to be bounced or dishonored by non-payment when the drawee banker of the cheque refuses payment upon being duly required to pay the same. Then we have discussed a very important section, section 138. According to section 138, under certain circumstances, a drawer of a dishonored cheque still be deemed to have committed an offence and shall, without prejudice to any other provision of the Negotiable Instruments Act, be punishable as follows. Imprisonment can be fixed, which may extend to 2 years. A fine can be fixed, which is twice the amount of the cheque, or both can be given.